Welcome to the March 17th, 2025 City of Clermont Code Enforcement Board meeting. Before we begin, I would like to advise everyone about the procedures that govern appearances before this board. This meeting is open to the public under Florida government in the Sunshine Law. The Code Enforcement Board is acting in a quasi-judicial capacity when considering individual cases. However, every effort will be made to hear all persons having relevant evidence or argument to offer in accordance with rules for such proceedings. We ask that each person who speaks before the Code Enforcement Board sign the sign-in sheet located on the table up front. After the opening remarks, all those who intend to speak today will be sworn in or affirmed. When asked if a respondent is present for your case, please come up to the podium. All proceedings before this board are electronically recorded. Please speak directly into the microphone at the podium and state your name and address clearly for the record. Additionally, please limit your comments to only information relating to the case being present. The City of Clermont has the burden of proving a violation exists. The city presents their case, and then the respondent presents theirs. Once all cases where respondents are present have been heard, the board will then hear the remaining cases. Each party may question witnesses offered on behalf of the other party. Additionally, the board members and their attorney may question those appearing before the board. This board will then make its decision based upon the evidence and testimony presented by both parties. The board's role is to determine if a violation exists and, if so, in most cases, set a date for violation to be corrected and set a fine if compliance is not met. It is not the board's role to advise you of a specific method or act that you can take to come into compliance. The Code Enforcement Board is appointed by the City of Clermont to review alleged violations and City of Clermont's Code of Ordinance fairly and objectively. Its members are volunteers and not employees of the city. The board's authority is limited to determining if a violation of the code exists. It does not have the authority to change the code or ordinance. Although you may have evidence, argument, or circumstances that could justify being excused from compliance with the applicable code, you are advised that this board does not have the authority to grant you an excuse. Such an excuse is commonly referred to as a variance or exemption and may be granted through other procedures such as application to the city, but not by this Code Enforcement Board. To avoid interference with this cases being presented to this board, all cell phones are to be turned off or silenced while in the chambers. At this time, I would like us all to stand and say our pledge of allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I would like to have one moment of silence, please. Thank you.
Madam Chair, we do have the election of Chair and Vice Chair this evening, but before we do, we have two new members who are joining us tonight. So it is my pleasure to swear you into your office at this time. We'll do Mr. Makowski first, and then go to you. So, sir, if you're able, please rise, raise your right hand, and repeat after me. Do you solemnly swear or affirm? Or I solemnly swear or affirm?
Solemnly swear.
That you will support the Constitution of the United States of America.
That I will support the Constitution of the United States of America.
The laws of the state of Florida.
The laws of the state of Florida.
And the charter and ordinances for the city of Clermont.
And the charters and ordinances of the city of Clermont.
That I am duly qualified to serve.
That I am duly qualified to serve.
Under the Constitution of the state of Florida.
Under the Constitution
and the Charter for the City of Clermont,
and the Charter of the City of Clermont,
and that I will well and faithfully perform
and that I will and faithfully perform
the duties of the Code Enforcement Board,
the duties of the City Code Enforcement Board.
so help me God.
So help me God.
Thank you, sir. All right. Mr. Ficasso, if you could please stand and raise your right hand. I solemnly swear or affirm
I solemnly swear or affirm
that I will support the Constitution of the United States of America,
that I will support the Constitution of the United States of America,
the laws of the state of Florida,
the laws of the state of Florida,
and the Charter and ordinances for the City of Clermont,
and the Charter and ordinance of the City of Clermont,
that I am duly qualified to serve
that I am duly qualified to serve
under the Constitution of the state of Florida
under the Constitution of the state of Florida
and the Charter for the City of Clermont,
and the Charter for the City of Clermont,
and that I will well and faithfully perform
and that I will and faithfully perform
the duties of the Code Enforcement Board.
the duties of the Code Enforcement Board.
So help me God.
So help me God.
And if you all would please sign that oath, I'll notarize it after the meeting.
Thank you.
And welcome.
Okay.
And now it is time for you all to do your annual election of a chair, and if you're the vice chair currently, if necessary, then an election for the vice chair.
Okay, I'll nominate myself as chair.
Second.
And do we have someone who wishes to nominate themselves as vice chair, I'm sorry?
Excuse me.
What?
Can we have a final vote for the chair?
Yeah, we do.
All in favor?
Aye.
Thank you. Now please move on to vice chair. Thank you.
I'd like to nominate myself as vice chair.
I'll second that. All in favor?
Aye.
Aye.
All right, thank you.
Okay. It'll be at this time, we need to approve the minutes from our last meeting. Has everybody looked over the minutes, and can I get a motion to approve?
I'll make a motion to approve the minutes from the last meeting.
I'll second them.
All in favor?
Aye.
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 Now, do we have any unfinished business?
Nope, the only thing I need to do is swear in the witnesses for tonight before we start.
Okay, please do so.
Each of these cases are quasi judicial proceedings. All testimony will be taken under oath. The formal rules of evidence do not apply, but basic notions of due process are observed for you and for the city. So if you're here to give testimony in a case, if you're able to, I'd ask you to please stand and raise your right hand. Do you swear or affirm the testimony you're about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated.
Okay, I'm sorry. My name is Avery Dyan. I'm the Assistant City Attorney. I'm just going to go over the order that we're going to go in tonight. First, we start with unfinished business. Items 1 through 4 all are present. So we're going to go item 1, case number C2404, or I'm sorry, 24040046. Case number C24040048. Case number C24040049. And C24040050. That's Lakefront Village LLC. That'll be item number 1. We'll move on to item number 2, which is case number C24050019, Linda Lauchan at 1870 Val Drive. We'll then move on to item number 3, which is C24090031. That's Edward Emmerich III, Cluster Oak Drive. And then we'll move on to item 4, C24060022. That's Libra Real Estate LLC at West Monroe Street. That would conclude the unfinished business. Then we would move on to new business. The individual for item 5 is present, so we'll start with item number 5 there, which is going to be case number C25010036, Lake Mineola Condominium Association at West Osceola Street. Since the individuals from item 6 and 7 are not present currently, we're going to skip ahead to item number 8. That is case number C24090026, Kendra Alum at 2950 White Magnolia Loop. And then we'll move on to items 6 and 7. Those individuals are currently not here, but if they do arrive, we will announce that. And then it'll be item case number C24120006, Colonial Tile and Paver, and item 7, C24020005, Selmager, Alexandra, and Adam at 26 Sunnyside Drive. Thank you.
Good evening, Board. Andrew Snodgrass, City of Clermont Code Enforcement. This is case number C2404-0046. As you can see from the bottom of this slide, this also incorporates cases 2404-0048, 2404-0049, and 2404-0050, as this property is a single building with 4 parcels. This is a reduction of fine request. The notice of violation notice of violation and the hearing notice from the case. The finding of fact from the May 20th, 2024 Code Board hearing. This is what implemented the fines on the property. The affidavit of compliance. As I said, there are 4 of these because there's 4 separate owners on one building. The letter included with the affidavit of compliance. So the board provided a compliance date of September 18th, 2024, 120 days for the permits to be issued. The fine amount was set to $60 per day for the parcel, for each parcel. Permits were issued on October 11th, so 22 days of fines accrued at an amount of $1,320 per parcel, 4 parcels, totaling $5,280. The fine reduction request from the respondent. So the total fine amount is 22 days, $60 a day, 4 parcels equaling $5,280. Staff recommendation is a reduction of the fine to 20% of the total. Staff recommendation equals $1,056 to be paid within 30 days, April 16th, 2025. Nothing further from the staff. Any questions?
Do we know what the delay was with the permitting? I mean, we gave them, I think, 120 days. That was,
The respondent is here if you'd like to speak with them.
okay.
Can you repeat your question, please? Turn your mic on. Is it on?
It's
Oh,
on.
maybe it is on. Okay.
My question was, I remember that we gave quite a long time, the 120 days to get permits. What was the delay beyond that? It went 22 2 extra days.
My name's Ross Germano, 2300 Main
city, and it only was released in October after the fire department actually issued the permit. That was the biggest delay. We expedited it through a company called BES to make sure that we could meet the date and start construction, but it went into the city, and then the review process actually, there are documents to support that if you need it. The review process was quite lengthy, and it usually ends up taking a while. We had told code enforcement that was an issue that we would be facing. So that's what happened. That's essentially.
Okay.
I apologize. I've never done this before. So.
Yep, no problem. Then city agrees that it was submitted timely, it just took a long time to review?
It did take a while. Fire department, I remember after his comment, the fire department was on, the reviewer was on vacation. So I
Okay.
did take away those few days. If there was any more time by the city, I did not take any time away.
I think we went in, excuse me, I'm sorry, I think we went in July, if I'm not mistaken, for the permits, or June or July is when we submitted them.
Does anyone have any other questions?
So I'm assuming then permit's been issued, work is ongoing or completed, occupancy, all those good things?
Work is being done as we speak, but we were issued also another notice by the city saying that they wouldn't issue any COs on the property until the road was repaved, because we still have a second building that we're working on.
Thank you.
So we're trying to get our COs, hopefully we can, so appreciate it.
Do we have a motion?
I make a motion that we accept the staff recommendation, equals of $1,056 to be paid within 30 days, which would be April 16th, 2025.
And if not paid in that time, is your motion that it will revert back to the original amount?
Yes, it would refer back to the original amount if not paid by April 16th of 2025.
Second.
All in favor?
Aye.
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 Thank you.
Moving on, Andrew Snodgrass, City Clermont. This is case number C2405-0019, Linda Lauchan, 1870 Vale Drive. This is a reduction of fine request. This is the second request. This is a repeat violation case. Previous case was heard on July 17th, 2023. That was the original case. Repeat case was heard July 15th, 2024, and the fine reduction hearing was held on September 16th, 2024. 90 days was provided at that time. It's the finding of fact from the first case brought before the board, 2023. It's the finding of fact from July 2024. So an inspection was completed on the property and found the property to be in compliance on July 25th, 2024. This was a Monday, so the compliance date was set for the previous Friday. After the inspection was complete, the owner requested a fine reduction packet and to attend the September Code Board hearing for a fine reduction. Affidavit of compliance with a fine reduction packet was sent out on July 25th via certified mail and email. Follow-up email requesting a fine reduction packet to be submitted was sent on 8/21 and again on 9/3. The fine reduction packet was received on 9/11. The owner has not stated the requested fine amount, but does state that she should not be responsible for the fine amount. This is the application from the owner. The Code Board hearing in September of 2024 reduced the fine amount to 20% of the total fine. The board provided the owner with 90 days to pay the fine. On December 10th, I spoke with the owner again, and she requested an extension to pay the fine since the house had not sold. I advised her that I could not grant the extension and that she would have to go before the board for that request, but that I would speak to our city attorney regarding the matter since the city has never had a second fine reduction hearing. On February 18th, 2025, I received an email from a title company requesting details of the fine and a payout amount. I advised the city would be following the legal orders of the Code Enforcement Board and that the amount to be paid is $30,500. It reverted back to the original after the 90-day time frame. February 18th, when I received that email, was 64 days past the 90-day time frame provided by the board. After discussion with staff and the city attorney, the owner requested to be placed on the agenda for a second request for a fine reduction. For the second fine reduction, staff recommends that 50% of the fine be paid. The fine amount is $30,000, so staff recommendation is to reduce it 50%, which would be $15,250 to be paid within 30 days, or it would revert back to its original amount.
Are there any questions?
Good afternoon. My name is Linda Rosher, 1870 Beale Drive, Clermont, Florida. I did call Mr. Andrew, and I just spoke to him regarding the situation, and I told him my property has not been sold yet, and I need a month or so to sell my property. Mr. Andrew told me that I can keep the charge, the amount to be paid of $6,100 until my property is sold. He told me plain he's making an executive decision to do so because he cannot get hold of the attorney to let the attorney know that I need some more time to pay my fine. I sent an email back to Mr. Andrew asking, were you able to get hold of the attorney to speak about our decision? He did not respond back to me, so I thought everything was okay for me to pay the $6,100 when my house has been sold. After now, I finally got someone to purchase my house. When they reached out, they said I have to pay back the original amount. I said no, but that's not what Mr. Andrew advised me of to do. After that, I tried to reach out to Mr. Andrew's supervisor. She did not want to speak to me. She sent me an email. Then I went above that, and I spoke to the above her. He told me was, right now, what I need to do, because I didn't have nothing in writing from Mr. Andrew, that I can pay the $6,100 when my house is sold. I have to go in front of the board, and the board would not have an issue of getting it back to $6,100. I said, okay. I also speak to Mr. Kristen, the new attorney. He advised me was, set up the hearing to go in front of the board, explain to the board what happened. And he also advised me is, he don't see a reason why the board would not allow me to pay my $6,100, because normally when a house is for sale to pay off a fine, they will give you at least 6 months for that to happen. So he said when I come in, go speak to him, to revive him, to let him know what the situation and what the case is. I am a single mom. I just started back working. Why would I not want to pay $6,100 and let it go back to $30,500? If Mr. Andrew didn't tell me that I can pay that out when my house is sold, I would have never done that. I would have borrowed, pay some type of bill or something to pay $6,100 instead of $30,500. Because of his advice, I listened to him, and that's what I did. When he told me that, I also consulted my attorney, because my realtor, because he's the one that's selling my house. I said I spoke to Andrew. Andrew said, when we sell the property, then I could pay the $6,100. I don't have to pay the full amount now. Because if I knew that was the case, I would have found some way, even borrow from him, pay $6,100 for it to go back to $30,500. And now when I try to reach back out to Mr. Andrew to ask him what's going on, he wasn't answering my phone call. I have tried everywhere. My last resource was to speak to the attorney, and I did spoke to him, and he said, go in front of the board. They should not have a problem giving you back to pay the $6,100, especially now that you have someone will buy the house and pay what is owed. I didn't appreciate that he told me something, and now when I call him back, he's saying something else on what he said. If he didn't tell me that, I'm not stupid to not pay 61 and let something to go back $30,500. A crazy person would do something like that. If he didn't tell me, I would have never done that. And it's not fair now, he's asking me to pay $15,250. I don't have that type of money. When my house is sold, now my house is in foreclosure because the bank lied to me and they didn't work with me. My house is in foreclosure. Everything that I'm getting for purchase the house is going to the mortgage to pay off what is owed. If I pay that, I have nothing left. I have to take care of my family as well. He shouldn't have told me that he's making an executive decision and allowed me to pay $6,100 when my house is sold. He should have never done that. And that was, in December, I reached out to him before my date to pay my fine. And Mr. Kristen also advised me and told me, he don't know why they put a lien on my property. But there should not have been a lien on my property. The only time there should have been a lien if I missed my due date for the 17th. They put a lien out way before the due date for me to pay my money that needs to be paid. So that's why when the mortgage people now pull up, they see there's a lien on it. They couldn't close on the house to do anything for me to even pay you earlier. They had to wait until another hearing date for me to resolve this problem. So there's a lot been going on, and everyone is telling me something over the phone, and when I call back and read them, they're saying, oh, I didn't say this, I didn't say that. That's not nice. I'm struggling enough to take care of this. The person who was living in the house never let me or my realtor in to do any repair. If he had let me to do a repair, this wouldn't be this way. And he only filed violation on me because he damaged my house after I evicted him. Before that, my house was perfectly fine. Is when I served eviction on him, he destroyed my property and called the code enforcement to say I have him living in my house like that, which I would never do that to someone. But my main thing right now, if Mr. Andrew didn't tell me that I can pay that money when my house is sold, I would have paid that money off already. That's why the attorney told me to come in front of you guys, explain everything, and there shouldn't be a problem of it going back to that because I have someone willing to buy it now. But I can't go pay 50% off. I don't have that type of money. I wish that didn't happen and I would have paid off if I knew to just pay it off. But I'm new to all this and I don't know any of these things. But I'm taking advice from Mr. Andrew.
Ma'am, I remember you being here before.
Mm-hmm.
So you do understand the procedures that when you came here, it's not up to him, it's up to the board to tell you what to do.
I didn't know that.
We explained to you what the fees were that you had to pay.
Mm-hmm.
And you walked out here and you understood what was going to happen. You had to pay this amount of money, and if it wasn't paid in that amount of time, it would revert back to the original fine.
Yeah,
That was explained to you, and you understood that.
yes,
And you also understood that he did not make that decision, it was the board that made that decision. So, you telling us that he told you he made an executive decision, the town people that work here, they don't make executive decisions. It has to go before a board. That's the reason why you're here now.
Yeah, he said he was reaching out to the attorney and let the attorney know this was happening and that it shouldn't be a problem for me to pay this when my property is sold. So I heard, and I listened to what he said. It shouldn't be a problem because he's reaching out to the attorney and let him know I just need a month or so to pay it off that my house is being sold.
Ma'am.
So that's the reason why.
Ma'am, and so your request to this board is that they, because the prior order reducing the fine to the $6,100 has expired. So are you're asking the board to reduce the fine to $6,100?
Just I can pay because I have someone now. Yeah.
Okay. Payable within 30 days?
Yes.
Okay.
Does anyone have any questions? Can we get a motion, please?
In your motions packet, the motion's a little bit broken off, but it's number 9 on the packet. The heading is on the bottom of the page, and the form of the motion is on the next page.
That would be on page 4.
Okay, I will make a motion that in case CEB number 2405-0019, that the existing fine be reduced to $6,100 with the stipulation that the reduced fine will be paid to the city of Clermont on or before 10 days from now, the 27th of March. Failure to pay the total reduced fine will result in the fine reverting to the original amount of $30,500.
Do I have a second?
I'll second the motion.
All in favor?
Aye.
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 Thank you very much, I appreciate that.
And you put a 10-day, on that? You said March 27th?
March 27th.
Thank you.
March 17th, 10, 27th.
Yep.
Good evening, Code Enforcement Board. Joshua Cortez for the City of Clermont. This is case number C2409-0031, Edward Emmerich E. III at Cluster Oak Drive. This is a reduction of fine request. This is the GIS map showing the property, the location. This is the finding of facts, the board's order. The city code section, 1853 for weeds. City code section 1854, declaring it a nuisance. City code section 125, 522, general development conditions, property maintenance. Property maintenance code, weeds. This is the respondent's fine reduction packet that they submitted. A picture of the property when it was overgrown. And a picture today showing that the property is still in compliance. The Code Enforcement Board hearing took place on November 8th, 2024. The property is in compliance. As of February 17th. The property is still in compliance. The total of fine amount owed is $2,500. The respondent requested a reduction of fine to $250 or 10%, and staff agrees to be paid within 30 days or the fine will revert back to the original amount. I have nothing further if you have any questions for me.
Does anyone have any questions?
I just was wondering why you would just leave that property go to be overgrown in the first place.
There was only one, portion of the property, and we don't actually live there. I don't live there, my dad doesn't live there. We thought somebody was cutting grass. I was having a friend do it at first, but he was in Eustis. Then we hired somebody to do it, and they didn't. And then eventually we finally got somebody to do it full time. But that's what happened.
Excuse me,
So-
can you please state your name for the record?
Clayton Emmerich, I'm here on behalf of my dad.
And your address?
1067 Calico Point Circle, Brooklyn, Florida.
Thank you.
So now that property won't be left untended, right?
No, sir. No, sir. We have somebody that is trustworthy to cut the grass consistently. We have no problem.
Okay. I make a motion that in the case C2409-0031, I move that the existing fine be reduced to $250, with the stipulation that the reduced fine will be paid to the city of Clermont on or before, what did we give them?
Be April 16th, sir.
April 16th. And if it's not paid by that date, then it'll revert back to the $2,500 original fine.
Second.
All in favor?
Aye.
Joshua Cortez, again, for the City of Clermont. This is case number C2406-0022, Liber Real Estate LLC at West Montrose Street. This is a vacant parcel, and this is a reduction of fine request. GIS map showing the location of the property. Copy of the board's order. The property maintenance code section for weeds. Weeds should not be in excess of 18 inches or shall constitute a violation. This is the respondent's fine reduction packet that was submitted to the city. This is a picture of the property when it was overgrown. A picture from today showing that it's in compliance. The Code Enforcement Board hearing took place on September 16th, 2024. The property was in compliance on February 1st, 2025. The property is in compliance at this time, and the total fine amount owed is $85,000. The staff recommendation is 20%, $17,000, to be paid within 30 days, or the fine will revert back to its original amount. I have nothing further if you have any questions for me.
Yes, ma'am?
I am King. My name is Giovanna Nunez. I am the realtor for my client. My address is 1500 Park Center Drive, Orlando, Florida. My clients are kindly request to reduce the fine to 10%.
Does anyone have any questions?
I have a question for staff on this one. I believe I was in the audience for this case back last summer, and the property owner was up on the stand there and stated that, you know, they were going to have somebody cut this. Is this that same case potentially?
I would have to look and
Okay.
see if we had a respondent present during that time, but I don't recall.
Okay, all right, just for clarification.
This wasn't the one with the sign on it that had.
Yes,
that
sir,
this
it
one?
was. It
I
was.
think this was the one they couldn't find the owner, right? You couldn't get in touch with the owner.
Right, yeah, I didn't believe we had a respondent present, but I
Yeah.
don't
Okay.
recall for sure.
So we've solved the problem of finding the owner at least, right? Now,
Yes, sir.
okay.
And the property has been kept in compliance.
Yes, ma'am, yeah, the property's in compliance.
I just have a question, staff.
Question is, 85,000 fine. How is that applied? How is that calculated?
Yes, sir, yeah, so from the time that the board put the order in to have a compliance date as well as the beginning of the fines, the property was in violation for 170 days. We actually have two cases. This is a very small parcel next to another vacant parcel. They're connected, but this particular case had basically the property wasn't in compliance for 170 days once the board had put an order out. So for each of those 170 days, you had a fine accruing.
And at that time, you couldn't find the owner?
No, ma'am. Actually, I'm starting to remember a little bit. Our city attorney was going to try to reach out to them. I don't know if you recall that, sir, but we did try to reach out to them. I know I did. The code enforcement manager, Evie, did. Our attorney did. No luck.
So when did you actually make contact with the property owner?
Well, I don't remember the exact date, but by the time they contacted us, that was right around the time the property came into compliance. So pretty much as soon as they, I guess, realized, that was when they contacted us for the first time. I didn't have any contact really prior until they came into compliance.
Okay, thank you.
Any other questions? Do we have a motion?
I'll make a motion, seeing as the property is, being taken.
Seeing as how the property is in compliance and it's been taken care of, I think the owner knows the value of keeping that property clean and free of weeds and noxious growths. And I would, in this case of C2406-0022, I move that the existing fine be reduced to 17,000, which is 20%, with the stipulation that the reduced fine will be paid to the city of Clermont on or before the
April 16th, sir.
April 16th, and failure to pay the total reduced fine will result in the fine reverting to its original amount of $85,000.
Second.
All in favor?
Aye.
Aye.
Anyone opposed?
I'm opposed to that.
So there are 5 of you currently present. It takes 4 votes to pass. I didn't hear specifically, Madam Chair, if you voted, you may have. If you did, you can.
Yes, aye.
All right, okay, so there are 4 votes to pass. It passes 4 to 1.
Sorry about that.
Evening again, Board. Andrew Snodgrass, City of Clermont Code Enforcement. This is case number C2501-0036, Lake Minneola Condominium Association. This is for unsafe structure. The location of the property via Lake County Property Appraiser. This is the violation notice posted on February 27th, 2025. The notice of hearing, which was also posted on February 27th, 2025. This is the affidavit of posting for the notice of violation. Notice of hearing. This is the actual picture of the posting on the property. So a complaint was received about the state of the building in mid-January. The complainant did not want to file a formal complaint at that time, but wanted to address the issue during their next HOA meeting. The complainant followed up after the meeting and filed a complaint towards the end of January. I was awaiting structural reports from the complainant before moving forward. Those reports were not received due to an email issue. So the case moved forward with a regular inspection. That inspection showed that the building is unsafe per the building services manager, director, and the building official. I spoke with the HOA regarding this matter, and they stated that they had an engineer's report which never stated the building was unsafe. That report was from May of 2024. Since then, multiple hurricanes and weather have aggravated the issues. The steel columns and concrete were addressed in the May of 2024 report as they were in need of repair. The property was posted on February 27, 2025. The HOA members, complainant, and residents were aware of the posting. On March 12th, I did receive 3 documents. Minutes from a February 2022 HOA meeting where the rusting support beam was addressed. Minutes from a February 2023 HOA meeting discussing the issues. And a structural report from September of 2023 which also addressed the issues. The HOA minutes from February 2022, the bottom you can see is highlighted. The rusting support pole on units 680 and 686 was discussed. No action was taken. From February of 2023, again at the bottom part highlighted, the rusty pipe outside of units 680 and 86 is still a concern. Insurance companies may require a structural engineer's report moving forward. And if that is the case, we're certain they will assess and make recommendations if there are any needed. This is an inspection report from September 6, 2023. These are photos taken on February 10th. As you can see, the picture on the left shows some cracks, some spalling throughout the concrete. The picture on the right shows the main issue, the structure, that post. That is the steel beam that's in question. As you can see, the concrete around it has also separated and has some issues as well. There are missing bolts from that bottom plate, missing bolts from the center, missing bolts from the top. This picture, the structural beam is on the right side. This picture. This is the bottom of that same post, which has rusted halfway through. This is more spalling throughout the same area, more cracks in the that second floor balcony. And this picture takes some explaining. The sliding glass door will not open due to the lintel above this area sagging. It's preventing the sliding glass door from opening. That door will not open due to the lintel above it sagging and putting weight on the door. Correct. There's nobody in that nobody occupying that unit at this time. So the staff recommendation to the board is to find the respondent in violation of sections stated and to assess a fine of $250 per day for every day the property remains in violation after May 16th, 2025. That's all I have. I'm open to questions, and the respondent is here too.
There's a question for staff. Could you just define spalling for me?
Spalling is cracks throughout the concrete that may or may not weaken the strength of the concrete and nominal load that it will take.
A more definitive thing of spalling is where you'll get water actually back behind the concrete and it actually pops it, so you actually get pitting and whatnot, is actually the true definition of spalling.
Thank you for that explanation.
It's good to have an architect on the board.
This is a condominium?
Yes, sir.
Are there people living in these buildings at this time?
At 680 and 686, there were not. The other side of the building, I believe there were. The building was tagged as condemned.
Sir, do you have anything to add?
We have an engineer coming out within the week, and we will submit the plans, and we will make the can you quickly as we can. I don't mean to interrupt you, but thank you, sir. Our engineer will work up the plans, we'll submit it, and we'll get the work done as quickly as we could. There was a hurricane that caused us to replace our entire roof on both sides of our unit, which kind of put off that work a little bit. But we'll get a plan together.
I have a question. Has the HOA had a third-party assessment of the property per the new Florida statutes to assess reserves and structural integrity of the property?
I'm not sure. I would have to get back to you.
Okay. Yeah, there's, after the collapse in Sunnyside, there's a new law in the books now that HOAs and condo buildings, I think it's over 5 stories, but still if you're under 5 stories, you're required to complete that, I believe, every 10 years.
Yeah, I think it's 718, state statute 718.
Yeah, so for your HOA, if you haven't done that yet, I think everybody was required to have that done, I believe, in 2024.
We've arranged for legal counsel. We'll have them working for us to assess all of those issues.
Thank you.
Do you feel it's safe enough for your residents to be living there?
We had an engineer from DBSS Engineering come out, and everyone called it the ugly pole. If we knew that it was as much of an issue as it was, we would have taken care of it immediately. But considering the sensitivity of Florida condominiums in today's environment, it goes to the top of the list now.
I do believe the state could come in there and just condemn it. If,
Well, we hope to replace that as quickly as possible. We're doing everything in our power at this point.
and that's kind of a very sensitive issue it's become here in Florida.
We're well aware of that, and that's why we're giving it the full attention. We've been working on this diligently.
Because all the liability will fall upon the HOA,
It seems that way.
the condominium.
We are working as quickly as we can to get that done.
And so in your packet of form motions, if it is your pleasure, number 5, this is a different type of hearing than the reduction of fine request, but it's,
I'll make a motion. Based on the testimony and evidence presented in case C 2501-0036, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter. That I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before May 16th, 2025. In order to correct the violation, the respondent shall take remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $250 will be imposed for each day the violation continues past.
Mr. Kilburn, I apologize for interrupting. We do have more people that want to speak on behalf of the respondents.
Okay. Cancel motion? All right, I'll withdraw the motion.
Apologize for that.
No problem.
do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thanks, sir.
My name is Joseph Dixon. I'm at 875 West Osceola. I'm the one that filed the complaint. All right. The HOA is working toward getting this done. We told them this is the consequence. In May of last year, I said I felt like no other choice but to take this to the board, if not addressed. Another engineer came in. Also, again, on November 7th, pictures were taken again right after the hurricane. So then said, again, kind of waiting, as I mentioned to Mr. Sidegrass, kind of waiting for our HOA meeting. I do want to, for record, there has been another structural engineer report that I sent to you that should be on file, along with stamped plans on how to make the repair.
Yes.
That we paid $2,500 for ourselves. I am the owner of the 680 condo, and that structure is adjacent to our property right there. Like I said, it was there, at that point it was just seeming to pull, but once we saw the structure, we had damage during the hurricane, flooding, we had to remove drywall from the inside. That's when the structural beam above the sliding glass door was exposed, and we saw the lintel crack and support beam. We can force the door open, okay, so at that time, so with some leverage, I can get in there and I can slide that through, but it is cracked. We just had another engineer look at it last week. Not only is the lintel, but there's sagging block and there's spacing above that, so it goes 3 blocks above it that supports that above. And right now, honestly, I've got some background in it. Honestly, you wouldn't give me a CO to occupy the building right now. So, but the HOA is working towards it, but we do have structural engineer plans on how to make the repair, so it could move forward quickly, all right? We wouldn't have to wait for another engineer to come in and for them to draft plans and for them to, it could actually start tomorrow. So, if plans were approved, we submit it that way. Thank you again for taking the time. I appreciate that.
All right, thank you.
The respondent an opportunity to respond if they'd like.
The HOA is working to correct this. This is an HOA issue, right? Or
Correct.
is it an individual owner issue?
No, the building is owned by the HOA.
Okay. We have submitted our engineer, this report by BBSS, I think you've received.
Is that a recent one?
This one's dated March the 4th. And then they have a report where they stand by their initial engineering survey.
Okay. So there's an engineer addressing that issue in particular?
The issue of the pole.
Okay.
That's correct. And then they're coming back out to reevaluate the situation and to put together their plans. So if it's an HOA issue, allow the HOA to correct the problem. A million engineers, you can have 3 engineers out there with 3 different opinions, and I think it's in best interest for the HOA to go forward and have our evaluation independent and have the recommendations that we will submit to the city for improvement.
Okay. I think Mr. Dixon was just trying to offer you the engineer's report, since he already paid for it out of his pocket, to provide to the HOA. If the HOA wants to get their own structured reports, their own engineering,
Yeah.
that's up to the HOA. That has nothing to do with the city.
We believe that sometimes, depending upon, the reports can be biased, and we want to make sure that at least, you know, if our engineer comes out and he makes the evaluations, you know, we have an obligation
Oh, yeah.
to the owners of the unit, and we want to make sure that we do this the right way.
I definitely agree.
Okay.
HOA can hire their own structural engineer. The city is only going to address the violation. The city is not going to go out there and get a structured engineer report or anything like
And
that.
we'll be, I believe, you can probably attest to this, but we've been in contact with you.
Very much, very much.
Every step of the way, maybe over communication, but we will make sure that we get all of the information submitted. 41 years, and we broke our record, so hopefully we can get this resolved as quickly as possible. We've just been the quiet neighbor down the street, and we hope to continue that. So we'll get this wrapped up. We'll have some plans submitted, and we'll get it resolved as quickly and safely as we possibly can.
I have a question.
Yes, ma'am.
Do you have any idea when you're going to be able to submit these plans so you can get this job started?
We have our engineer coming out within the week, and they understand the gravity of the situation. I think that when there's an issue on condominiums in Florida, it opens up all kinds of sensitivity. So they're aware of it, and they're working as expeditiously as possible. I would like to give you a date, but my sense of urgency is completely different from everyone's, and I'd also know that permitting and approvals and things take time, but we're doing everything in our power to push that forward. I too am in a role as a condo board member in a voluntary role and have other jobs, but this one has taken the majority of my time since the notification, and we will continue to give it that effort.
Thank you.
And solely for purposes of the record, the board's order, whatever it is, will not touch upon or address, or nor do they have authority to which engineer you use, which, you know, plans. That's
I just think
up
it's
to you all.
prudent to get a balanced opinion.
Yeah. Not part of their purview about picking engineers, but it was just for benefit of the record.
Thank you.
Does anyone have any further questions?
I just have one other question. Are the residents aware of the problems with the structure?
Oh, yeah, it's not every day you have this kind of excitement at our condo. Everyone is aware. And we're, like I said, we're working as quickly to resolve this as we can.
Another question.
Actually, the owners of the upstairs unit are present here as well.
Question for staff and maybe even for the city attorney. So if they have engineered plans submitted to the building department by May 16th, does that constitute bringing the property into violation or into compliance?
The violation still exists. The violation needs corrected.
Okay.
That was 60 days given. I was under the impression that plans were readily available to be submitted. So 60 days was what I provided. It's up to the board to provide less, more, however you.
So for clarification, it's 60 days for the plans to be submitted to the city, or?
60 days for the violation to be corrected,
Okay.
especially due to the fact that this issue was brought up in a 2022 HOA meeting. And again in 2023. So
Do I have a motion?
I'll make a motion. Based on the testimony and evidence presented in the case C 2501-0036, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before May 16th, 2025. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with the order, a fine of $250 will be imposed for each day the violation continues past May 16th, 2025. Respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Second.
All in favor?
Aye.
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 Ask a procedural question. If once we submit to the city, what's the timeline for approval?
You have to talk to the building department with that, said code enforcement.
Yeah, I was just wondering if this is a week, if it's 2 weeks, and where we are in the process, so that we can plan accordingly to be in compliance.
I will say, you'd have to contact the building department for a definite answer. I've seen permits take a week, I've seen them take a month. Depends on what all documents are included.
Okay, thank you.
Good evening again, Board. Andrew Snodgrass, City of Clermont Code Enforcement. This is case number C 2412-0006. It's Colonial Tile and Pavers LLC. This is a building permit required case. The notice of violation was sent out on January 27th, 2025. It was returned February 22nd as unsigned for. So the posting of the notice of violation, posting of and mailing of the hearing notice was done on February 26, 2025. This is the location of the property via Lake County Property Appraiser. This is the notice of violation, the notice of hearing, the affidavit of posting. I spoke with the owner via email on December 5th regarding work being done on the property. She stated that pavers were all that was being replaced. Nothing else was being added. I advised her at that time the impervious surface area would need to be measured, and this addition has never been inspected or recorded. The property was scheduled for a site review for food trucks that were added to the property. During the site review on December 11th, the owner was again advised that a permit would be required for the pavers. Multiple emails have been sent to the owner since the site review on December 11th with no response from those emails sent from Code Enforcement or sent from Development Services. The food trucks that were on the property have been removed from the property. That was a separate case. That was why they were coming in for the site review. Pictures from December 4th, 2024, showing some of the work that was being done. Photos of the food trucks from that day, more the area in question, the parking lot in the back. This is the impervious area where all the pavers have been added. As I said, none of this has been measured. This is a posting of the property. This was posted on February 26th. This is February 28th, where the posting had been removed. This is an email from Development Services to the property owner dating January 17th, 2025. Describes the additional pavers, the request for a variance, or the need for a variance. Email sent on January 3rd to the property owner with no response, and on February 5th to the property owner again with no response. Staff recommendation is to find the respondent in violation of section stated and to assess a fine of $250 per day for every day the property remains in violation after April 16th, 2025.
I need to swear you guys in. Sorry, because you came in late. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you all very much. And for the record, Mr. Snodgrass was previously sworn when the hearing started.
Speak it to Mike.
Yeah, can you speak into the mic? Sorry, thank you.
My name is Araceli Herrera, owner of Colonial Tile and Pavers. I'm here because the amount of pavers that I have in my commercial property, and I just have some clarifications to make in regards to the pavers. I've been the owner since 2012 of the building, and the pavers have been there since before that, since 2009. And we always have the same display area. These are pavers that I use as a representation of what I sell. And from time to time, I change them because, you know, there's new products and new things coming. So all the pavers that are installed in that area, they're all removable, and most of them are permeable. They have been there for many, many years, and I never had any issue or any water, any issues whatsoever.
Yes, sir. Could you,
My name is Ernesto Leonard, and I kind of manage the company. He owns the company, but I
your
manage the
address, please?
Say that again?
Your address, please? The same address?
Yes.
Okay, okay.
I just help her run the business and everything. So, of course, you know, we only know so much about, you know, legality, this, that, and so my question would be like, of course, you know, for the person who knows more than us, would be him, I guess. So, what I'm here to, trying to understand is, since the paper's been there for so long, you know, so what's the reason it's just all this happening now, and what would be the legal amount? I would, you know, we would like to know, based on the amount of land that we have, how much it is that we can actually legally, you know, cover up on it. If it's a removable display, because it's not a permanent structure, you know. I do concrete and I do a lot of pavers all over the place. And usually when you do a concrete driveway, it cannot be removed. I mean, it can, anything can be destroyed, but I mean, it doesn't count as a permanent structure. So all these pavers are displays. We sell them, we remove them, we get a new one from different companies, we put them again. So it's not like a permanent structure that is damaging the ground. Most of the pavers that we have is permeable, so they let the water filtrate. The same thing they're using all over Mineola. That's the only thing that is allowed here. So we kind of trying to get an idea. Where did we cross the line from right to wrong? That's what I'm trying to figure out. Nothing that we cannot correct it, but it was never asked for before, for many, many years. I've been here for 25 years, working pretty much in Kingsbridge my whole 22 years here now. And all of a sudden this happens, so we're trying to figure out what is it that we did wrong when it comes to a space that we cover. So pretty much, yeah, definitely we can fix it, but I would like to know how come this, you know, came to happen now, because I was always told that displays that are removable doesn't count as a permanent structure, so they can actually be applied to it as long as you use the right material for the ground. So that's all. So I'm trying to find out where are we within the legality, where did we cross the line from right to wrong, I mean from right to wrong, yeah. So I would like to get some information on that.
Okay. After speaking with the attorney real quick, basically you needed a permit whenever it went in. There's no statute of limitations on a violation. So I can't tell you that, oh, it's been there for 5 years, it's good now. It doesn't need a permit. It doesn't need the required inspections. It doesn't need the required setbacks and things of that nature.
So do we need a permit for driveways in
Yes.
County?
Yes.
I never knew that. I mean,
Well,
anybody goes
During the site review that was on, what was that date?
Like I said, I don't know,
December,
that's what I'm trying to-
okay, that was whenever you were told during that site review that you do need permits for that, piece of property and for those pavers.
Because of commercial?
Regardless of whether it's commercial or residential, you need permits for the pavers.
As a person, I've
It's,
been doing
Clermont.
favors in Kingsbridge for 22 years.
I can tell you that it's not unique. Almost every jurisdiction, county and city, has a permit requirement for pavers, and while I don't see it here as often as I see it other places, because it's a smaller community, every day at code enforcement hearings, there's, somebody put in this beautiful, nice, either walkway or driveway with pavers, and they didn't pull a permit, and they're here.
So what he was saying, I've been doing pavers in Kingsbridge for many, many years. When the HOA asks, so when a client is ready to do a paver driveway in Kingsbridge, the HOA from Kingsbridge asks them to come here to the city and tell them to sign a paver and telling the city that they're gonna do a paver driveway. They're never tell them, oh, you need to have a permit then. Then they bring that paperwork to the clubhouse, sign here, I think it's the notice of commitment, but I've never, ever had to do any kind of permitting. Why any of my clients in Kingsbridge ever have been told to do a permit for a driveway?
So, so my understanding is what you're talking about is just driveways. So what you're discussing there is a like-for-like replacement. So you're putting in pavers where they already are? Is that what you're saying? Or you're taking concrete out? So that doesn't change the impervious surface of the property. So code states that so much of your property can be impervious surface. So I don't know exactly what the code is off the top of my head. That's a different situation. So in your situation here, by you setting up the display area, you have now covered up more of your property of impervious surface that is allowed by code. So even though you say your pavers are pervious and do allow water to saturate through them, you would then have to, I would assume this would have to go to building department, and then they would specify how much you can cover on your property with the pavers, and then you would have to then scope in your permit saying that this is the type of paver that is used and it is a pervious paver. That is my understanding how the process would work. So I would think that, whatever, I would think that whatever staff here, is stating is they saw you probably changing out pavers, so that's new work to the area, and, you obviously are then violating the city code for the amount of impervious surface or not having a permit for this new work area. So this is kind of where my understanding is where you're at.
Since-
That's totally through building department, so we're just here to deal with the
So
code
that-
violation at this time.
That would require a variance, which you were supplied with that information at that meeting as well. I believe you were supplied with a variance application at that time too. The city of Clermont, especially since you have a paver company, the city of Clermont has a 55% impervious area. So 55%, and does require permits to measure that.
So bottom line, so we need to come to the building department and find out exactly how much can we cover based on our survey?
55% of your property.
5%. So that's what pretty much we gotta do to be in compliance?
You need to get the impervious area permitted as well.
All right, so get a permit for whatever has been done, and then remove whatever is over the excess, I guess.
That's something you could
Correct.
discuss with the building.
Yeah.
Right.
Correct.
Or you could then apply for the variance to go over that
Yes.
55% if you wanted to go that route as well.
Yeah, Kingsbridge is only replacement, so I know what
Yep.
you're saying. We don't add any Kingsbridge, we replace it only, so.
And again, we mentioned Kingsbridge because it's
Right.
a place that we
Because
work there,
everybody
but
knows.
we do pavers all over it whenever.
All right, so I guess we gotta get into an appointment with the building department, I guess?
This email here from January 17th, it has the variance application applied to it. So you can download the application and apply if you'd like to go that route.
No problem.
So does anyone have any further questions?
I just have a question with staff.
Yes.
A business, no matter how big it is, the big box stores or whatever, if they're in the business of retailing or selling pavers, can they set up a display of the pavers on their property without getting a permit?
No, you would have to be required to get a permit, regardless if it's something that you sell. If it's something the city requires to have a permit for, say if I sell driveways, I can't just put down driveways. I have to get permits for those driveways.
Yeah, I'm not
That's a
talking about,
crazy explanation.
I'm not talking about driveways, I'm just talking about a product.
If you want to put them
I see
outside,
the stores
outside on a rack or something like that.
outside the building. I see Home Depot has it, and I see the other one,
Lowe's.
Lowe's. With,
Yes.
they'll have their wares out in front of the building.
Yes, they could do that. They could have a warehouse with material somewhere else and it's drop
Do
shipped.
they need a
I'm
permit
just addressing this one,
to
though.
put their wares out in front of their building? That's all I want.
Yes, he
They
can.
do.
He can, yes.
Okay.
Does anyone have any further questions? May I get a motion, please?
Yeah, I'll make a motion. Based on the testimony and evidence presented in case CEB C2412006, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinance as listed in a notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before April 16th, 2025. In order, correct the violation, the respondent shall take the remedial actions as set forth in the notice of the violation. If the respondent does not comply with this order, a fine of $250 per day will be imposed for each violation that continues past April 16th, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
Second.
I'll second.
Okay.
All in favor?
Aye.
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 One last question, if I may. So how many violations are we violating?
One building permit required.
Let me tell you what.
Yes.
Okay, good. Thank you, sir.
You're welcome.
Oh, I'm sorry, you know what, they're not here.
Yeah, 6 and 7 are here.
All right, thanks.
Good evening, Code Board. Joshua Cortez for the City of Clermont. This is case number C2409-0026. Kendra Alam at 2950 White Magnolia Loop. City Code Section 125-522, building permit required. City Code Section 125-587, vacation rental permits, permit requirements, permit required. This is a overhead view from property appraiser showing the property's location. The violation notice was sent out September 20th, 2024. That was received on the 25th. The compliance date is November 19th, 24. The hearing notice was sent out in February 4th. That was received on February 7th. The results of today's inspection is that they're not in compliance. I thought I updated this in the cloud. I guess it didn't go through, but they're not in compliance as of today. This is a copy of the violation notice, as well as the package delivered notification from USPS. The hearing notice and its delivered notification. Some additional information on the case. On September 20th, 2024, the community association manager for that neighborhood emailed code enforcement asking us to check into the owner, advising that they are building a small building behind the home and did not have HOA approval. The CAM also stated that they have a small apartment built on the side of their home and have a tenant, and asking if there was anything that code enforcement could do. On September 20th, I went out to the property to do an inspection, and upon arrival, I saw two gentlemen outside the home. I exited my vehicle to make contact with the individuals, and the first gentleman that I spoke with was a gentleman washing his car who advised to me that he was a tenant there. The second person I spoke with said that he was the fiance of the property owner and allowed me access into the side yard. Once I was in the side yard, I observed the two sheds, some paved area, a screen enclosure, and French doors. That same day, after having gotten in contact with the property owner, a site visit was arranged and access to the interior of the home was provided. Upon inspection, I asked if I could see the tenant's area from inside, and the respondent advised no, because it was strictly the tenant's leased area. I explained that permitting would be required for the additions and alterations and for the rental that she was providing. The respondent advised that the tenant was going to be leaving soon. As of today, there's 3 permits in the system. Permit number 25-0111 for the 2 sheds has been issued. 25-0112 for the screen enclosure is in review currently. The plans have been rejected, and the plans examiner is requesting an engineer's letter. 25-0106 for the French doors is in review currently, rejected. The plans examiner is requesting an engineer letter. This is a photo of the property taken from Google Street View as of April 2014. This is a Google Street View photo of the property as of August of 2019. And what I'd like to point out to the board, as you're looking at the photograph on the right side of the structure, you can see that there's a window. And as I go to the next photographs, you'll see the alterations to the structure that have been made. This is a photograph of the front of the structure taken on September 20th, 2024. This is a photo of taken from the side yard of the side of the structure, showing the screen enclosure and French doors. This is a photograph showing a shed, and then off in the background a little bit you can see another shed, as well as some paved areas. Another photograph of the screen enclosure, shed, the other shed, the paved area, screen enclosure. A picture taken December 16th, just showing the property. This is basically a printout from our Track It system showing that this particular permit for the screen enclosure over an existing slab has not been approved or issued, and that the status is still in review. This is the permit showing the French door installation. The status is rejected. It's a little bit of an error there that it says issued. The permit tech who initially received the documents made an error and put issued. We weren't able to change it, unfortunately. It's just locked in the system, but as of right now, the plans have been rejected and the status is rejected. The staff recommendation to the Code Enforcement Board is to fine the respondent in violations of the section stated and to assess a fine of $150 per day for every day the property remains in violation after April 16th, 2025. As of today, shortly before the Code Enforcement Board hearing took place, the respondent came to City Hall to drop off a couple of engineered letters for the 2 outstanding permits. I believe that she has copies for the Code Enforcement Board that she'd like to pass out. But those have not gone through plans review yet, so the permits are not issued. So once the plans get reviewed, you know, we can go from there, but as of right now, they're not, you know, the permits are not issued. So I have nothing further if you have any questions for me.
Yes, I have a question. What is the reason for needing a permit for the French doors?
So the reason for the permit for the French doors is that initially the structure did not have that. If I go back here, which is why I had that photograph from 2019, that is an alteration to the structure. So there were no doors there. What you're seeing on the right side is a window and like a hose, basically, that's kind of wrapped up. But to basically take a chunk out of an existing wall to modify a structure in that
I
way,
see.
that would require a permit.
I see.
What I see is, looks like an eyebrow above that window. What is that?
On the right side, sir?
Yeah, on the right side, in double windows, looks like an eyebrow. Well, you didn't put the door in by the two windows.
Let me go to the, so this is kind of what you're looking at there. Yes, sir. Yes,
I
sir. Yes,
see.
sir.
I see.
Go back to the staff recommendation.
Well, I make a motion,
Just a moment, sir. Just a moment. Ma'am, could you state your name and your address, please?
Sure, sure. Good evening, Board. My name is Kendra Elam. I reside at 2950 White Magnolia Loop here in Clermont, Florida. And I don't know if you want me to speak or respond.
It's
Okay,
your time.
yes, I would like to respond to what Mr. Cortez said. Yes, they did come out and he did fine me for the structures. And so I came down here to get that rectified. I would say the first 3 visits that I came was kind of trial and error because I didn't know what I was doing. And when the first time I came to get the permit, they said that I need the engineer for it. And I said, okay, so I went back and got the engineer plans, and so when I brought them back a second time, they said that they were not how they, I guess, wanted them to be. And so I had to go back and get the plans how they wanted them. They wanted them separately. And so I did that, went back and got them how they said they wanted them. And so when I came back the third time, they still were not accurate up to, I guess, how they wanted them to be. And so I said, well, can you talk to the engineer yourself and explain to them what it is that you're needing, because every time I go back, I have to pay for additional plans. And so, let's see, what's her name? Jennifer. I asked Miss Jennifer to talk to the engineer herself, talk to the engineer himself to explain to him exactly what he needed. And so she did on the phone. She told him exactly how they needed to have them done. And so I came back a 4th time, and the plans were the way that they wanted them. However, there was an issue. They said that I needed a letter regarding the door because the door, they were trying to explain it to me. Anyway, they said that it needed a letter confirming that the structure was good for the door. And when I was kind of upset about it because I wasn't told that during the 3rd time when she talked to the engineer, a letter wasn't mentioned at all about the door. The letter was mentioned on the 4th time about the door. So I was a little taken back about it. I cried because I just was trying to understand why they did not tell, Jennifer didn't tell the architect that when she spoke to him on the 3rd time. And so the 4th time, they rejected it because they said they needed a letter. I said, okay, write to me exactly what the letter needed to be so it's not rejected. And then I have a note from Dawn, I have a copy here, of what the letter needed to say about the door, basically, and I'll read it verbatim what she said. The engineer letter said that it needs to state that it was built to code. That's what she said. The letter stated it was built to code. And that was not stated on the 3rd time. So I talked to the engineer, told him exactly what I needed, and the day after I got the letter, I got a call from Mr. Cortez about the situation, and he said that the sheds were approved, and he said that they needed a letter for the door, which I was aware of that, but also he said I needed a letter for the screened enclosure. And at that time I was I was upset, and just be honest, because I said that was not mentioned to me. The 4th time I came, I was only told about the door, that I needed a letter for the door. And the reason I was upset, I'm sure you all are aware that it's very expensive dealing with engineers and the plans and everything. And so he said, well, we need a letter for the screen enclosure as well. And I said, well, I'm gonna go and talk to Dawn because she specifically, it was 4 people there, and they all said, this is all that you need and everything will be approved. And so I went back to her and I said, you guys didn't mention anything to me about needing a letter for the screen closure. And, you know, she said, well, I'm sorry, well, this is what we need. And for me, because it's coming out of my pocket, I have to go back to the engineer again. This is my 4th time going back to engineer again, so more money, thousands of dollars out of my pocket to get it corrected when it was not correct the first time. And so I got the letter, finally, because it's costly. Anyway, and so I got the letter, and I brought the letter to him today. The shed has been done. The shed is completed. I'm just waiting for them. It's to come in to inspect it, which is on Thursday. And so I've given them the letter. You know, hopefully this is it. But for me, I just kind of wanted to explain the whole process. Is I just didn't understand why I wasn't told in the beginning everything that I needed in terms of the letter. I'm new to this. I'm only going by what they're telling me, you know, what I need. But it was 3 times, we need this, we need this, we need this. And it's been additional documents. And for me, it's time off of work. It's extra money to, you know, the engineers and all of that. You know, I
Yes,
do
ma'am.
realize I'm not compliant, and I'm trying to be compliant. But just the process of things, of just trying to understand what I've been through, of the back and forth, and the money. You know, more for me, it's the money. And so I just don't understand how that happened, why I have been having to, you know, to keep going back and forth.
We understand.
And then to add to the rental, yes, the people there, they're my friends. She moved from Hawaii, her and her husband, and they moved here. I'm sorry.
Ma'am, we just want to stick with the permits and
Okay.
stuff like that.
Oh, because he mentioned he mentioned a rental something violation. That's why I was trying to bring that up. But if not, then I'll stop there.
Yeah, I think we do need to address the rental because it's on.
Okay, yeah, and so, yeah, when he came, and he did talk to my friend and her husband moved from Hawaii after my husband passed about 3.5 years from cancer, stage 4 cancer. And so she said, well, I'm in a pickle. It's expensive here for us to live. I said, I'm in a pickle. I lost my husband. I have my 2 adult children come back to live with me, as well as her to help me pay the bills. And so, yes, they're renting it, but it's no rental contract. Everybody, my 2 adult children, as well as them, we all pay the mortgage. We split the mortgage. We split the electric bill. We split the light bill. And so, yes, he is, you know, initially paying rent. They all know on the first, give me your part of the money, but they're not tenants. They set an apartment on the back. You can see the pictures. There's no additional building that's built. We all live under the same roof. We all share the kitchen. We all share the same bathrooms. They just live there, and we all live under the same roof, and we all help with the bills. That's what that is. So there's no, you know, what they're saying, you know, I built an apartment. He saw there's no apartment built, so I don't even know why that was said. You can see the structure that was not true. And even with them coming inside, he came inside my house. There's no separate anything. We all are under the same roof. So it's just been frustrating to me with the whole process. It hasn't been smooth. It's been very, very costly because I felt, you know, in the beginning, had I been told, look, this is what you need, I would have went to the engineer and got everything that they needed. And this is 4 times I've had 4 different occasions that I've gone to the engineer, and it's been a cost to me and not to the city, my time, my money, because I wasn't told what I needed initially in the beginning. But to solve all that, I'm hoping that this is it. I pray this is it. And I did give them the letter, you know, that they needed. So I'm just hoping that this is it. I'm just, you know.
I actually have a question for the respondent. Does your who was residing in that little area? You said that was a friend of yours, correct?
Yes, her and her husband. The husband is the gentleman that you talked to.
Okay.
She and I, we made, because I'm not friends with her husband, I'm friends with her. We made the arrangement. They're living there. We all live on the same roof, and we just split the bills.
Okay. Does the tenant have access to the rest of the home, or are they kind of?
They all have access.
Okay.
Yes.
Is there anything in the tenant's room? Is it like a makeshift little unit for them? Do they have a sink? Do they have a toilet that's installed for them?
No.
They have access to the rest of the home.
Yes.
They're just in that room. Okay.
Correct.
Okay. Any further questions?
Yeah, I have a question for staff. On the violation notice, if I can just understand. Number 1 is the shed, which is the permit is received but not approved, correct? Number 2, the slab underneath, is that included with the shed permit?
Yeah, so
That was-
for permit number 250111 for the 2 sheds, that does include the paved area along with it.
Okay, so that's number 1 and number 2. The screen enclosure is a separate permit.
Let me just go to the notice here.
There we go. Yeah, that's what I'm reading, 1, 2, 3, 4, 5, 6.
It could have potentially been if they've, and it is currently, I mean, you know,
Okay.
we never know if they may wrap up things together in certain permits or what have you. But yeah, as of right now, the screen enclosure is a separate permit, I believe, along with the, yeah, so the
The
screen
French
enclosure
door.
is its own standalone permit. The French doors are its own
Okay.
permit.
And the lumber shed is part of the first permit. Now, the configuration of the kitchen, is that another permit that is coming? That's number 6 on that page.
So that was worked out between the respondent
Okay.
and staff. That's not an issue.
Okay, that's good. And then potentially the short-term rental is not an issue?
So when the complaint came across to code enforcement and the way that I perceived it,
Sure.
I thought that it was sort of a sectioned off unit,
Understood.
which I do see fairly often where the tenant will not have access to the rest of the home. They'll put a toilet in there, and it's basically a little efficiency unit.
Sure.
That was kind of what I thought it was, which is why I had some clarifying questions for the respondent.
Okay. And Ms. Elam, you are protecting the privacy of the room your tenants, your friends live in.
Yeah, I
Is why
told
you
them
wouldn't
at
let
the
him in
time,
there.
right,
Okay,
when they're
that's all.
sleeping,
I just,
said I didn't want them to be
Right.
disturbed. That's why they
Understood.
told me we couldn't go in.
Okay, thank you, and thank you, staff.
Okay, do we have any further questions?
So then is staff then vacating the code violation for the vacation rental permit based on what you've just discussed?
Yes, we can.
Okay.
So at this time, we're just looking for a building permit? for
Yes,
the
ma'am, that's
door?
correct.
Okay. And at this time, you are working with the staff to give them paperwork, and you've been working with them to
I
do
gave
all-
them everything that they
Yes.
needed, so I'm
Okay.
waiting to hear back from them. I'm hoping there won't
Okay.
be another thing
And-
that I need. So this is, like I said, this has been 4 times where I
Okay,
thought I submitted them what they asked for, and it's been something additional. So
Okay.
I've given them what they need. I'm waiting to hear back from them, basically. They
okay.
have everything from me.
And the time that you are requesting for this to be in,
30 days. 30 days. Go back to it there. Oops.
I'm sorry, I didn't mean to interrupt. Would they get a response from me in 30 days? I mean, will y'all respond to me within that time? Because kind of the ball is in your court, so I'm waiting on you. So will y'all, like, get back to me in 30 days before the deadline?
Yeah, so I believe that our plans examiner should be able to take a look at everything. And if everything's correct, definitely we should be able to have the permits issued within 30 days.
And if not, would I be liable for that?
Well, if the documentation's not correct and our plans examiner kicks it back, you know, then it could potentially take longer. I'm not the plans examiner, I don't know. If the letter suffices them, then yes, the permit should be issued based on what I understand, but
And I
I'd
have a
have to go
question.
to them.
Is there anyone, I don't know, who I can talk to in the event it's not correct? If there's something additional, what would be my next course of action? Because I felt that I've complied in giving them what they've asked for. And I've given them what they asked for. The issue has been, it's been something additional each time. Everything has not been, okay, this is everything that we need from you. It's been, okay, we need this, and I come back, oh, we need this. Oh, you know what? Oh, we need
Yeah.
this.
We've-
And so,
We've heard that.
yeah, so I
Heard
don't
that.
know.
So-
I'm just trying
so
to find
all-
out, like,
All this board can do is give you time to come into compliance.
okay, I understand.
So, the city's recommending 30 days until April 16th. If you want the board to consider a different time,
If you
tell 'em
would,
what.
in the event, I don't know if you could, a little bit more time,
But-
in the event that it may take them a little bit longer. I don't know if that's,
So I have a question for staff and the board. Would we consider 60 days based on her experiences of having to go back and forth a few times?
I think the staff recommendation of 30 days, I'm going to stick to that recommendation, but of course, if the board feels differently, then by all means.
I'd be amicable to a 60-day.
Yeah, I would too.
yes.
None taken, none taken.
May I get a motion, please?
Okay. Based on the testimony and evidence presented in case C2409-0026. We move to find the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, and that I have considered the gravity of the violation, any actions by the violator to correct, and any previous violations by a violator. I move to order the respondent correct the violation on or before May 16th. May 16th. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 a day will be imposed for each day the violation continues past May 16th. The respondent is further ordered to contact Code Enforcement Officer Compliance and to arrange an inspection of the property to verify compliance with this order.
May I get a second?
I'll second that.
All in favor?
Aye.
Aye. You have to May 16th.
Thank you so much. I appreciate it.
You're welcome.
I'm sorry, is there anything else?
So this will be item 7, case number C2402-0005. Alexandra and Adam Settlemodger at 26 Sunnyside Drive. City Code Section 125-522, building permit required. Property Maintenance Code 703.3.3, firewalls, fire barriers, and fire partitions. Required firewalls, fire barriers, and fire partitions shall be maintained to prevent the passage of fire. Openings protected with approved doors or fire dampers shall be maintained in accordance with the NFPA 80. This is the IPMC Property Maintenance Code 110 stop work order section. And just as a quick note, when this notice was drafted, in our computer system that we use to generate notices and so on, the notice of violation was actually incorrectly numbered as 112. And so I just want to put that little note down there that it's just purely an issue of numbering. The text of the code itself, nothing has changed. It's just strictly the numbering. But the stop work order section states that any work performed in a dangerous or unsafe manner, the code is authorized to issue a stop work order. Property Maintenance Code, Unsafe Conditions 111.1. Property Maintenance Code, Unsafe Structure 111.1.1. This is a overhead view from Lake County Property Appraiser showing the property's location. The violation notice was sent out on February 5th. That was received on February 7th of 2024. The compliance date was April 5th of 2024. Hearing and violation notice were sent out January 21st, and the date that was received was the January 23rd. The results of the inspection as of today is that the property is not in compliance. This is a violation notice and USPS tracking showing that it's delivered. Looks like some of you are reading that, so I'll hold off on changing it. Ms. Falcone, are you still reading it? I don't want to move on if you're not ready.
No, I'm good.
Okay.
Sorry.
Notice of hearing, as well as the USPS showing that it was delivered. This is a Google Street View photo of the structure from July of 2019. On the left, you're looking at the front of the structure, and on the right, you're looking at the rear of the structure. These are some photos taken. Sort of a collage of photos that just show some of the work that was being performed when I had stopped and first observed the property. This is a stop work order that was placed on the deck structures. The back door to the structure was open upon my arrival. There were contractors and other workers that were on site during the time of my inspection, and I did speak with them about the stop work order. From the threshold of the door, I took a few photographs of what I was able to see from the doorway into the structure. The building official determined that the building was unsafe and should not be used or occupied. That was on February 5th, 2024. I met on site with the respondents and the then Chief Building Inspector, Bob Spears, on February 6th, 24, to better assess the scope of work and help the respondents determine what will need to be submitted for permitting. Some photographs of the inside of the structure during my site visit with the Chief Inspector. This is a permit here showing that it's applied for and actually approved, but just not issued. The staff recommendation is to assess a fine of $250 for every day the property remains in violation after April 16th, 2025. I have nothing further, if you have any questions for me.
Is the city requesting a health and safety tag?
Not at this time, no, sir.
Josh, could you go back to your slide on your, like, date of tracking that you had for when you first initially were at the property, posted violations? This is more.
I think you're looking at this one, is that?
No, what, couple more. Keep going. Like where you said you.
Oh,
first,
condemned it?
Yeah, you had, no, you had it was just the text slide that had the dates.
Right here? You talking about this one?
No, one more, keep going.
Trying to help you out here.
I think you had to go back the other way.
All right, let's see. This one?
That's the one.
Okay.
Yeah. Just, this is more a question for my own curiosity.
Mm-hmm.
Why did it take from April of 2024 until January to get to this point?
There's a lot of factors. I mean, working with the respondent, having the respondents.
So you were in the process of
yes,
getting
sir.
things done,
yeah.
and then it got to the point where they just kind of fell off.
And for a little bit there, they were working with the city pretty diligently, trying to make it maybe from a duplex to like a quadplex, light commercial, and it just didn't work out. So there was a lot of things they were trying to do at that time, but it just kind of pushed the whole process out.
Okay, thank you.
Yes, sir. And the January hearing was canceled, so there's that.
I have a question. You said there was an approval?
Yes, ma'am. Yeah, so the permit's approved, and so far as I know, it's just pending payment. I've spoken with them several times to try to get this permit actually issued, to no avail.
I see.
So at this
So
point,
the reason why it's not issued is because it hasn't been paid for?
correct. Yeah,
Okay.
So far as I understand, that's the only thing that's missing. There was a period of time where they were missing some of the subcontractor information. So far as I understand, that's been rectified, and it's purely an issue of payment at this point.
I see. Is there anyone here representing?
I don't believe so. No, ma'am.
Okay. Does anyone else have any further questions? May I get a motion, please?
I'll make a motion based on the testimony and evidence presented in case CEB C2402-005. I move to find that the respondent is in violation of the City of Clermont's Code of Ordinance as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before April 16th, 2025. In order to correct the violations, the respondent shall take the remedial action as set forth in the notice of the violation. If the respondent does not comply with this order, a fine of $250 per day will be imposed for each day the violation continues past April 16th, 2025. respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
May I have a second, please?
I'll second.
All in favor?
Aye.
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 Before we adjourn, may I just have a moment just to address you all? We have two new members, and so typically at least once a year we do a full Sunshine Law public records training. Just want to get, and some of you are probably very familiar with it, but to cover my own rear, I want to just cover the high points to keep you out of jail as a volunteer advisory board member. Sunshine Law, any discussions you have with other members of this board, it only applies to the members of this board, not you speaking to a member of a different board. Those communications about any matter which may foreseeably come before this board, whether it came today or came before or may come again, those communications, oral, written, however, can only happen between the gavel, when the meeting opens and when the meeting closes. Can't talk about a case on the way to the parking lot. Can't talk about a case when you sit down at the dais 10 minutes before the meeting starts. The best rule of thumb is when in doubt, don't, and when in doubt, call me before taking an action. The public records is very similar. Anything, if you have a Yahoo account, a Hotmail account, not a city account, anything having to do with this board, whether it has to do with whether you're going to attend or not, any of those things, those are all public records, and they have to be maintained and not destroyed. An intentional violation of the Sunshine Law, meaning you willfully violate it, is a second-degree misdemeanor. It's a fine, and you can be removed. Negligent, mistaken, unknown violation that you commit, you can still be removed and still be fined, all for being an unpaid volunteer. So usually what happens is people in the audience or somebody who's not pleased with what happens sees you walking with a colleague out to your car, you're talking about your grandkids or what you're going to do this weekend, but they don't see what you're saying, they just see you talking. So when in doubt, don't. It interferes sometimes with good courtesy and the manners that we were all taught to behave with other people. It doesn't mean you can't talk to a colleague on the way to your car about your vacation plans. It just means be aware of your surroundings and who might get the wrong impression. The good news is to actually be a violation that someone can move on, they actually have to have seen or heard what it is you say. So we defend these cases all the time. If they see you talking but they don't know what you were saying, there's no inference that you're committing a sunshine violation. They actually have to see it or witness it. So when in doubt, call me. When in doubt, don't. I think that's it.
I make a motion to adjourn? Ooh, I cannot.
No, you can't.
Sorry.
You can. Yes, ma'am.
I'd like to make a motion that we adjourn.
I'll second.
All in favor?
Aye.
Aye.